First, as requested by response counsel as a final chance based on 18.
Page number 3, number 9 to 14.
That is also 2017. As requested, list in the next week. 9, 8 to 9 to 10 Then there are two matters. One is SPP. Yes, what is say? At least if you are ready, you can argue. Correct. Our ಶುರುನೇ ಮಾಡೋದಿಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ who is your senior counsel engaged? We should argue the matter, old matters. We are not insisting on new matters. 2016, 17, 11. At request of the response counsel as a final chance based on date. 17. Here, at 9, 10, 11. Yes. But each one of you go on seeking adjournment like this in old matters. Old appeals will be pending and the blame will be against the court. All right, in first list, who are ready in the first list? Adu innondu connected matter. Adrallu avare idare. Mr. Chandrasekhar RP. Adralli a connected appeal is of the year 2015. This matter already, that matter will adjourn, but this matter will not adjourn. 2015. If see, please take it for noted. If you are not ready in the old matters, they are going to appoint amicus curiae and hear the matter. It's not fair. Now ಓದ್ಕೊಂಡು ಬರಬೇಕು ನೀವು ಬಂದು ಇಲ್ಲಿ adjournment ಕೇಳ್ತೀರಿ ಅಂದ್ರೆ ಹೇಗೆ? She is seeking in 10. 7. ಇದರಲ್ಲಿ ಯಾರು SPP ಸಂತೋಷ್ ಬಿ ನೀವು ರೆಡಿ ಇಲ್ಲ? ಯುವರ್ ಮ್ಯಾಟರ್ ಇಸ್ 2015 ಬೇಲಲ್ಲಿ ಇದ್ದಾರೆ ಅವರು. ಬೇಲಲ್ಲಿ ಇದ್ದದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರೋದಿಲ್ಲ. We'll adjourn if they are on bail. We'll adjourn it on payment of cost. 11 ನಿಮ್ದು ಬೇಲ 11. As requested by the appellant's counsel as a final chance based on date.
18.
12 ನಲ್ಲಿ both counsel by the appellant in this matter seek adjournment. The corrected matter. The matters are pending since 2015 and 17. The appellants are enjoying the benefit of bail. Therefore, under circumstances, time granted on payment of cost of rupees 5,000 each are payable to the High Court Legal Services Committee. List on date. What is cost? ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ಲ. ಸೀನಿಯರ್ ಮದರ್ ಅಡ್ಮಿಟ್ ಆದ್ರೆ ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ ಹೌ ಮೆನಿ ಇಯರ್ಸ್ ಸರ್ವಿಸ್ ಯು ಹ್ಯಾವ್ ಪುಟ್ ಇನ್. ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿ ಮತ್ತೆ ಜಡ್ಜ್ ಅಟ್ ಲೀಸ್ಟ್ ಫೈಲ್ ತೆಗೆದು ಓದಕ್ಕಾದ್ರೂ ಶುರು ಮಾಡ್ಬೋದು. ಲಿಸ್ಟ್ ಆನ್ 18. ಈಗ ಯಾವ್ದೋ ಇನ್ನೊಂದು 18 ಅವತ್ತು ಇನ್ನೊಬ್ಬರದು ಹಾಕಿದ್ದಾರೆ. ಆಯ್ತು 18 ಇರ್ಲಿ ಅವತ್ತೇನು ಎಷ್ಟು ನಡೀತೆ ಗೊತ್ತಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪರ್ಸ್
number 4. Number 15 to 20.
ಯಾಕೆ ಫಸ್ಟ್ ಟೈಮ್ ಅಂದ್ರೆ after how many years it is listed for the first time? ಅದ್ ನೋಡ್ತೀವಿ ಹಾಗಾದ್ರೆ ನೋಡಿ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. Because we are coming across the cases where once the sentence is suspended for 6 years the matters were not listed. And at least they should be listed. See, the same, see, it was when we inquired in the registry, the same thing was said to us also. At least 3 times we were sitting consecutively for criminal appeals. We never gave any instruction not to list the matters. ಸುಮ್ನೆ ಮತ್ತೆ judges ಮೇಲೆನೆ ನಿಮ್ಮವರು ಬೇಲಲ್ಲಿ ಇದ್ದಾರೆ ತಾನೆ? 60 as requested by the appellant's counsel as a final chance list in the next week. Yes. Office objection. Yes, second set of yes. You. No, now the other counsel is also there. No. Then will. They do not represent. Yeah, no. Recall the order dated 17/11/2023. This appeal is of the year 2017. Because they have not appeared, the amicus curiae was appointed. 17/11. Get appointed through High Court legal. He was also appointed through High Court Legal Service Authority. He was also between Hegde was who has filed this application? Between Hegde only. Right, okay. I order dated 17/11/2023. The advocate who appointed by High Court Legal Service Authority to represent the appellant
So dated so the advocate
on 17/11/2013, noticing that the advocate appointed to represent the appellant by the High Court Legal Service Authority remained absent continuously. In his place, Srimati Sohani Hulla, advocate, was appointed as amicus curiae. The above IA is filed seeking recalling of the said order. The office objection. Again, the same said counsel Vipin Hegde is absent. Office objection is not complied. Therefore, the application is rejected. For non-compliance, Srimati Sohani Hulla, Lower Counsel, is permitted to continue to represent the appellant. The paperwork were ready. SC paper. List for final hearing on
19 months.
Thank you.
Number 2.
Communicate the copy of this order to the HCLC and non-compliance of office objection. I put the last one 2.4. You represent. Hello. With the appellant, complainant is the appellant in that case.
State has also different. That is serial number 2.1. State has also different.
He has preferred against SC 47 of Tucson. You said case and counter cases were there. Acquittal is in case about two. No, he has preferred appeal against SC 47 of 2013. Here, accused 2, 4, and 6 are sentenced to 6. 1 second. Order of conviction. 1, 5, and 7 to 11 and 13 are acquitted for 143, 148, 302, 307. Case number 3 was also acquitted. Only accused number 2, 4, and 6 were convicted. A 2, 3, 4 were convicted for 324. So his appeal is against acquittal of those accused. Complainants appeal. He has to comply. No, 1, 5. State appeal is in order now. Paper books ready ಆಗಿಲ್ವಾ ಅದರಲ್ಲಿ 2.4 ಅಲ್ಲಿ ಬರ್ತದೆ. No representation of the appellant's counsel. Finally, 2 weeks time is granted to the victim, telling which the appeal shall stand is fixed. 2 to 2.3 ಅಲ್ಲಿ ಬರ್ತದೆ. The paper book shall be prepared 2022. It was admitted 2022 ನಲ್ಲೇ admit ಆಗಿದೆ. Within 2 weeks. At least after 2 weeks.
Hearing of IAS. It is Soma Reddy.
Suspension. Who is what is it? She was not examined before the trial. So? No, she was not examined before the trial. Who has filed this application? Ashok Kumar Shetty. He is not present. Yes, sir. You were not examined before the trial court. Why do you want to get impeded now? She was cited as a charge sheet witness. But she was not complainant also. Who is PW1? Avinash. He is not related. No, was it paid? Is it under 357 or accused have office is directed to forward the copy to the District Legal Service Authority. District Legal Service Authority determined it at 3 lakhs. Huh? But operative portion of the order does not say.
Operative portion because just before the operative portion, my lord, ask paragraph that
5 lakhs. Yes. It is in this context, court directs the District Legal Service Authority for payment of 5 lakhs. ಅದ್ರಲ್ಲಿ ಏನು ಸೀಲಿಂಗ್ ಇದೆ ಅಲ್ವಾ 357 ಏನಲ್ಲಿ 357 ಏನಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಲೆವೆಲ್ ಸರ್ ಇದೆಯಾ 357 ಏನಲ್ಲಿ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿಗೆ ಮಾಡಿದ್ಮೇಲೆ ದೇ ಹ್ಯಾವ್ ಟು ಡಿಟರ್ಮಿನ್ A determination, there is some policy for that, how to determine. And there was also a circular or it means something. Courts cannot decide. The disciplinary service authority has to determine. Court cannot decide. Compensation.
Or accept.
ಅದೇ ಏನೋ ಒಂದು ನಾರ್ಮ್ಸ್ ಇದೆ ಅದಕ್ಕೆ
Compendem ಇದು.
ಅದ್ರ ಪ್ರಕಾರ ಕೊಡಬೇಕು. Orders and I number 2 of 2023. Please filed the order of conviction and sentence passed against the appellant for the offenses punishable under section 302. 302 ಮಾಡಿದಲ್ಲ 302 201 read section 34 IPC. The applicant is the mother of the victim. She was neither the complainant nor filed as a charge sheet witness. The trial court has awarded certain compensation to her. Now she wants to come on record. Then assist, only she can assist alva, independently argument ಮಾಡಕ್ಕೆ ಹೆಂಗಾಗುತ್ತೆ? How can you can assist the ಯಾವುದು section 300 ಏನಾದರೂ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆಯಾ ಹೊಸ CRPC ಅಲ್ಲಿ? Assisting the prosecution, which is that provision? Assist the prosecution ಅಂತ ಇದೆ. The prosecutor has to commence something. What's the public prosecutors? 21. Three not one ಇರ್ಬೇಕಾ?
Bucket 2.
The very public prosecutor has to commence something. Private person instructs the pleader to prosecute any person in any court. The public prosecutor conduct the prosecution. You can do only that much. Written arguments I can submit. Written arguments. In view of the aforesaid facts and circumstances, the applicant is permitted to come on record and assist the prosecution in terms of section 301 into bracket 2 of CRPC. 1973 ಅಂತ ಹೇಳಬೇಕು ನಾವೀಗ 1973. ಇನ್ನೂ ನೋಟಿಫೈ ಆಗಿಲ್ವಲ್ಲ? Okay. The appeal shall be amended accordingly and the copy shall be served on the copy serve ಮಾಡಿದ್ರೆ ಒಂದು ಕೊಡಿ ಮತ್ತೆ ಅಸಿಸ್ಟ್ ಮಾಡಕ್ಕಾದ್ರೂ ಬೇಕಲ್ಲ applicants counsel. Okay, you are ready for this? Very good. You have gone through here CC in bail suspension. Yes. They have not filed objection. When this application was filed?
1973.
He was on bail during trial. ಯಾಕೆ 19 song, it was not listed there after filing the application. Now we heard. At request, 1 week time is granted to do the needful in respect of IA 2 of 2023, 2610. Thereafter, you are not complete, then let them file objection if they want. ಅಲ್ಲ ಕರೆಕ್ಟ್, ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ ಈಗ ಮಾಡಿದೀರಾ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
They just are publishing their read orders and entire evidence etc. Publishing.
Oh, records are not received.
Therefore, they are. And any one sentence they will say, they will be on court may not be the kind of document. Are only order, bail order.
ನಮಗ್ ಕೊಟ್ಟಿಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವ್ದು ಇನ್ನು.
Bail order, only page number 1. First bail order in the order. Para 3 case of proceeding that on 75 at about 11:45 p.m. assistant to one the proceeding covers human around the bike and it is got out from the bike and then during the to smoke great the action taken to one Russian release the coming and at that time in reply life at the spot and advance independently on the permanent this is supposed to use compared to part from the one proceeding and advance 5 more in refer to but say those are one that do not indicate the injuries goes to the other I got because on 24th February 2020 and as far as what is concerned,
But that is at pre-conviction stage. Now whether those witnesses have supported them. ಕರೆಕ್ಟ್ ಅವ್ರು ನೋಡ್ಬೇಕು ಅಂತಾರೆ, ನೀವು ಕೊಟ್ಟಿರೋ ಪೇಪರ್ಸ್ ನೋಡ್ಬೇಕು ಅಂತಾರೆ. ಬಿಕಾಸ್ we are also not aware of this. Your furnished copies are furnished to you. No concept for that. Appellant submits memo with copies of documents. ನೀವು ಅಲ್ಲಿ ಕೊಡೋದಿಲ್ಲ, ಯಾಕೆ ಇಲ್ಲೇ ಕೊಡ್ತೀರಾ ಡೈರೆಕ್ಟ್ಲಿ? ಯಾಕೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲೊಂದು ಇಂಡೆಕ್ಸ್ ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಏನೂ ಹಾಕಿರೋದಿಲ್ಲ. ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ನೋಡಿ ಪೇಜ್ ಇನಿಷಿಯೇಷನ್, ಅದಕ್ಕೆ ನಿಮಗ್ ಮಾಡ್ಕೊಟ್ಟಿದಾರಾ? ಗಿವನ್ ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಕೊಟ್ಟಿದಾರಾ ನಿಮ್ಗೆ? ಮಾಡ್ಕೊಡ್ಬೇಕು. ದೇ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ಸೋ ಮೆನಿ ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನ ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಬರ್ದಿಲ್ಲ. ಕರೆಕ್ಟ್, ಬಟ್ ದೇ ಶುಡ್ ಮೆನ್ಷನ್ ಇಟ್ ಇನ್ ದ ಇಂಡೆಕ್ಸ್ ಅಲ್ವಾ? ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ವಾಟ್ ಆರ್ ದ ಲಿಸ್ಟ್ ಅಂತ ನಾವನ್ನ, ಇಲ್ಲಾಂದ್ರೆ ಡೈರೆಕ್ಟ್ ಟು ಫೈಲ್ ಇಟ್ ಇನ್ ದ ರಿಜಿಸ್ಟ್ರಿ. ದೇ ವಿಲ್ ಡೀಲ್ ವಿತ್ ಯು ಪ್ರಾಪರ್ಲಿ. Submits memo with copies of the documents. Learned HCP 6 times. 6 times. We got to the fact that the documents are produced today. Okay. Appearance counsel shall make a proper index of the documents produced. List on. If you want any particular date, we'll list it. Mm. 18th or 19th? 19th. 18th we listed so many final year.
Number 4, Raj Shekhar case.
in support of their economic development, 90. Among them, PW1 is the mother. PW2 is neighbors. PW3, no, there is no I. PW1 is mother. PW3 is sister. PW7 is the father. The evidence because the function of another or not his own wife and mother.
How long they were married?
And one small child is there. So 1 year back before the
The incident took place on 3/9/2017. Yes, what was your explanation regarding death? It has taken place in your house. You have admitted it to be the homicidal death or not? Due to pressure, throttling. Correct. There are no eyewitnesses. Case was based only on the circumstantial evidence. But the death has taken place in your house. It is an unnatural death. What was your explanation for that?
These are not supported. Only neighbors, PW3 is the neighbor. PW12 after evidence is not fully supported.
Death was due to pressure on neck anta idu. So throttling.
And number 15,
Risky zone.
and number 15.
Para 15 is yes.
In the class examination, PW12 stated that the iron bone was not completely fractured and it was fractured only on the right side and that a person can come to see. Even when lying. Yes, denied that if a person is immediately released from the hanging position, the ligature marks should not be found. He admits that due to construction of the face may turns to fish and that no thumb impressions are said to be found on the neck of this. No thumb impressions are said to be found on the neck of the deceased. Whatever it is, if a person had pressed the neck of the other with hand, the fingerprint marks may be found on the neck, and they are given in case of hanging, there will be a pressure over the neck. If other that as per the PA report, there were only operations and confusions on the neck of this. No inside parts have
Correct. What is your explanation under section 313 CRPC? The accused has failed to provide satisfactory explanation by way of adducing defense evidence as well as in his statement recorded under section 313 CRPC. That's what the trial court says. Page 21, internal page 21, running page 31. But you should have produced the evidence as to what had happened in his house on that day. Internal page 21 or ink page 31.
incident of the movie that the who are bothered with people understand. Next.
ಇವಾಗ ನಿಮ್ಮ ಮನೆ ಮಾಡಿದ್ರೆ ನೀವು ಸ್ಟಾಪ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾ ಇದೆ ಅಂತ neighbor ಹೇಳ್ತಾರೆ. Yes, ಏನು explanation ಇಲ್ಲ. And neighbor says you made the child to stand outside and locked the door and went away. Yes, what do you say? Anything else? Is there anything else you want to say? What is the material to show that child is in your custody? ಏನಾದ್ರು ರೇಷನ್ ಕಾರ್ಡ್ ಏನಾದ್ರು ಹಾಕಿದೀರಾ? All probability child will be in grandparents custody. We should have reported the matter first to the police if it was a cause of death was any other thing. Vivek Annan ಆಗಿದೆ. Yes. Page number 31. ನಿಮ್ದು ನಮ್ದು ಪೇಜ್ ಕರೆಕ್ಟ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ ಹೇಳಿ. Internal page. Yes. Yes. Strangulating ಅಂದ್ರೆ any other object was used. Case of throttling. Strangulation ಅಂತ word use ಮಾಡಿದ್ದಾರೆ. Strangulating the neck and by putting the clothes in her mouth. Legal services ನಿಮಗೆ SCLC panel ದ pro bono ಅದೇ ಕಷ್ಟ. CL ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ. ಆರ್ಡರ್ಸ್ number 2 of 2023 are both side and forensic records. And interim judgment in the order, the appellant is convicted. The offense punishment is continued into IPC and sentenced to life imprisonment. Allegation against the appellant is that on 29/2017 at 9:30 p.m. in his house. See, at Mysore. The appellant suspecting the fidelity of his wife, Ashwini, quarreled with her and committed her murder by throttling her. It is further alleged that after committing such murder, he locked the house, making the ಎಷ್ಟು ವರ್ಷದ ಮಗು ಅದು, making his child to stand outside the house. She so and so long also for the appellant submits that the appellant was on bail during the trial and the case is based solely on the circumstantial evidence. Canada SPP submits that
SP2.
He
SP2.
submits that. That though the case is based on circumstantial evidence, the chain of circumstances are complete to point only to the guilt of the accused. Appellant. And he failed to rebut the presumption under Section 106 of the Evidence Act. Yes, sir. The consideration for grant of bail at pre-conviction stage and post-conviction stage are different. At post-conviction stage, the presumption of innocence of the accused is not available. The trial court order, the infant judgment reveals that the appellant did not dispute that his wife died a natural death in his house, and he was not found thereafter at home. He did not explain that also. Properly explain that also. As per the infant judgment, the other material witnesses are supported the prosecution case. Considering the gravity of the offense and material on record, it's not a fit case to grant suspension of sentence and bail. Therefore, the application is rejected. Paper book shall be prepared with 2023, within 4 weeks. This soon after the preparation of the paper books. Yes. Rejected.
Number 5, Rajendra BC.
The application has been examined PW 1 to 19 cases and got marked exhibit P1 to P21, exhibit P1 has been marked and the demo 1 to 19 has been marked. The applicant can see this case, the register certificate in the charges against the accused, rather than section 376, 302, so I will remember I can see yes. Yes, number even for mind. Actually, you can see here the registration there connected the offense punishable section. So, section the accused sentence to undergo into yes number 165, 86.
Yes.
So, 76, then this IPC to pay fine of 10,000 indeed for 5 years, for a period of 5 years for the offense under section 377, federal section 5 of IPC. So on file of this, then to the independent of payment of 5, that is should undergo period of 1 year. And further, that is further sentence to undergo for life and pay fine of 10,000 for the offense. Regarding of IPC, in the part of payment of fine, we shall undergo simply for a period of 1 year. The next concern. The accused is sentenced to undergo legal sentence for 7 years and pay fine of 10% for the offense of 1 of IPC. In return to payment of fine, we shall undergo for a period of 1 year. So, something about detention already undergone, I think that that are the three facts of the prosecution case in that manner. The term 16 to the two date that is clear. The mother has ability to detect for not a content. that was 66. There was a program near Mariam Arasangalima temple at Nalurandi. Dinner was also arranged there. Her 4 daughters had gone for there, but only 3 returned home. When she asked her for first daughter, she went to Assam, asked what happened to this missing daughter. She told that that is have taken to the providing some job intervals for her. They think did not enter here. Thereafter, the company informed the same to her husband. It is served Saswara. On his return to the house, the company to the husband. Some relatives in the Ramagunda, in certain and that is but could not find them. On the next one, the king is found here in the Nalurandi circle. When he was asked about he told that he had committed rape and the mother and her dead body in Nalurandi and immediately the complaint and the others went to Nalurandi and found the dead body. Based on they have not largely so missing complaint in this case. The entire case is stands on confidential level. It is that the appeal that undergone so more than 1.5 years sentence. Was arrested on 17/6/2000 on the next day.
Why there was such a delay in trial? Why the delay? There was such a delay in trial. 2012 to 2019,
Yes, madam. Right.
7 years.
7.
And appeal is filed in 2023.
I see.
Custody of the child. So you have referred the appeal belatedly.
Yes, sir.
He is responsible for this delay. He is responsible for this continued incarceration. Whether now we can take that factor into consideration. He is in custody for 12 years and sorry, but court was not responsible. You filed the appeal belatedly. Then there was extrajudicial confession.
There is no mechanism for extradition. So
This
only
lady?
for the accused.
Mahadevamma, she has supported that.
The accused is
No, extrajudicial confession.
confession.
So last scene that the sister says that
Sister said,
he picking up the child, she's
and
and doctor's evidence shows that there was an attempt of rape as per the judgment. It is on this. 12 is also. Who is PW12? 12 and 13, but sister PW2 is the.
She has clearly stated in the class that subject the affidavit.
No, if you want to argue, we'll hear you further. ನಿಮ್ದೇನಾದ್ರೂ ಇದ್ರೆ ಇನ್ನು ಮುಗಿಸ್ಬಿಡಿ ನಿಮ್ದು. You completed or you wanted to still argue? ಹೇಳಿ ಹಾಗಿದ್ರೆ. So you stopped there.
The entire case is stands on circumstances today. Where the case is stands on circumstances today, the change will be so accurate. So in this case, there was no real circumstances. So the mother of the victim, she admits in the classification, she does not know what is written in the complaint. Actually, even she has clearly stated in the classification statement. So hence who is stuck this is Asama and support the case of the classification. She is eligible that when you are sitting in the line, or taken before. She did not notice as to who took the receipt from there. Just we are in the class. So there was a function when I not one or two after that ನಾಲ್ಕು ಜನ ಹೆಣ್ಣು ತಂದಿರ್ತಾರೆ ಅಷ್ಟು ನಾನು ಕೂತಿರ್ತಾರೆ ಆ ಜಾತ್ರೆ ಇದೆ ಆ ಜಾತ್ರೆ ನಡೀತಾ ಇದೆ ಊರಲ್ಲಿ ಆ ಜಾತ್ರೆ ಇದ್ದಾಗ ಯಾರು ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ನಾಲ್ಕು ಜನ ಜನ ದೇವರ ನಾಲ್ಕು ಆಧಾರ ಸಿಂಬಲ್ ಸ್ಪಾಟ್ ಸೊ ಯಾರು ಕರ್ಕೊಂಡು ಹೋಗಿದೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತಿದ್ದಾರೆ ಅಂತ ಯಾರು ಸೊ ಅವ್ರು ಊಟ ಮಾಡ್ಕೊಂಡು ಅವರು ಯಾರು ಕರ್ಕೊಂಡು ಹೋಗಿ so in the class examination we are not stated okay significant people are really later department so period 4 into 4 who is a constant so as now last time is not supported this last time so period 9 the garage is the class examination the disease containment so no extra disease completion full by class. The extra disease completion is not enough to be transcription layer. So but the 9 the admit the points are not recorded statement they have taken layer. There is 9 is also current option is not applicable to the transcription. It also 10 is also the continuity is also current option layer. It has to 11 minutes is accompanied there. Otherwise, she was sitting in the chair. She was sitting in the second chair there. It was the chair with bracket. They are not so supported in case of the classification. She is repeated in 11. So, I am going to agree with that. She is not supported in case of classification. So, it is 7. Oh, it is one of the so getting one of is a developer. PW7 is supported in case of the transmission method because the victim and the parents are also working under the PW12 method. Hence, they are supported in case of the transmission method. So
was not detected.
So that at least already undergone 1.5 years sentence.
Yes, that's all. Yes.
Implementation date of the manifest at 90. Told one as the matter of substance to the soil of faith. When you are raised the power of increasing on Agra, the headlight of the path, other in the obedience of opinions, in the hand. Is totally to that as sentencing to the goal. At our 8 to the end, son, and father which the people are facing. Similarly, turn off open the need. And 36 months of we will very narrow that is involved. I don't care anything. Itself and control of any electricity. Look again, look again. The other everything that see. These are 7 ideas in the decade of plan. We have also put that on something to go. We will turn it out into the work and very. He came to that said and died. And when he went to the house of his son and saw the different in the current hand, seen the city of the instituted a population to think that they were bringing an incorporated who was having the power of capacity. This is about 7 to 8 years prior to the same. Further is that on 16 people go around 8 again, when you are doing the art, you are thinking the country. It is not enough of watching of fusion, this is a living element as well as it's all considered a fusion. So, other than it's not going to be that there are about 800 members.
Then 17 of judgment. Yes. Yes.
Well, there are still individual problems. These are this particular the prosecution is able to establish the fact that the victim was had the case. To know what happened on the day was picked up by the appeal and taken out to the regulated and tried to commit grave on her, and they were not successful enough. The penetration to the vagina of the victim and in order to screen the evidence of the sand of the victim, he has known the victim no right and beyond all the door. Having held that, the appeal had asking the victim of the evidence of the victim, and the dead body found in the short period of time. The opponent to the victim had seen the victim of the case. And also having regard to the fact that the lure is small is okay. And not having this population, there is no right of the man that is accused and that is the most. After the evidence of happening, there is also a review of number is 45 47 and not 7.
Ish.
Page 45 the meeting doctor remember because that examination going and then 1 year and from the following. Okay, getting ready from external area, confidence arrange the body hands here and this. Scratch operation on the front of backside of one number parallel to the okay. So the area shows green. Yes, other people that get connected. Last two lines. Yes, given the phenomenon meaning as the UPC 17, stating that the net was being stopped as a result of injury to the genitalia, whatsoever is definitely evidence of sexual harm, we can write on the front. Other, yes, other people that in this one, anyone, and they are fresh. And the release of bacteria from the rats and bacteria, and then also the release of lungs was because there was still some trace of life, and the child was thrown into the water. There is another people that death in the system and falling as well as attack. This is the 70 of one. Yes. That is appeal. But become the disease along with drugs in the night of drugs become insane. According to drugs, largely they follow it to 13. And there are servants of doctor father than drugs. Had a small entire
In the trial also he was not granted bail. Not applied or not granted. During trial, whether he had not applied or had not granted. Legal service on ಅನ್ಸುತ್ತೆ. Accused, he has been provided legal aid. Pre-legal aid ಕೊಟ್ಟಿದ್ರು. There was not only 515 days delay, there was more than 515 days delay ಅಂತ ಕಾಣಿಸುತ್ತೆ. The judgment is passed on 4/12/2019. And this appeal is filed on 19 January 2023. 2 ವರ್ಷ ಎಷ್ಟು 3 ವರ್ಷ ಆಗುತ್ತೆ ಆಲ್ಮೋಸ್ಟ್. ಅಡ್ಮಿಟ್ ಆಗಿರ್ಲಿಲ್ವಾ ಲಾಸ್ಟ್ ಟೈಮ್ ಡಿಲೇ ಕಂಡ ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ admission outside admit matter request detailed consideration admit call for TCS paperwork shall be ಇದರಲ್ಲಿ 7 years ಇದು ಬಿಫೋರ್ ಇದನ್ನಲ್ವಾ ದ ಚೈಲ್ಡ್ ಇದು ಮಾಡಿದೀರಾ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ ಸೊ ಇಲ್ಲ ಆದ್ರೂ ಸೆಕ್ಷನ್ 437A ಅಮೆಂಡ್ಮೆಂಟ್ ಕೊಡಿ CRPC ಹೋಗ್ಸೋ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೂ 437A ನೋಡಿ ಅಮೆಂಡ್ಮೆಂಟ್ 37.
And Jagjit Singh case. Jagjit Singh case reported in 2022.
You have to implead them also. Well, they have to be heard whether implead or not. 437A ಅಂತ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಯ್ತಲ್ಲ ಇದಕ್ಕೆ into the accused 35. few days earlier ಅಲ್ವಾ ಆಕ್ಟ್ ಬರಕ್ಕಿಂತ ಡೇಟ್ ಆಫ್ ಅಫೆನ್ಸ್ ಎಷ್ಟು 16/6 14/11 ಬಂತ 439A amendment 2018. The presence of informant or any person authorized by him shall be obligatory at the time of the hearing of application for bail to a person under section 376(3). 376 ಎಪಿಸಿನ ಕೊಡಿ below 15 years ಇದ್ರೆ ಬರುತ್ತೆ ಅನ್ಸುತ್ತೆ 376(3).
7 years.
376 ಇರೋದು
Jagjit Singh.
ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇಂದ ಒಂದಿದೆ. ನಮ್ಮ brother single seat ಆಗಿದೆ. He's 76 years. ಇಲ್ಲ, 376, whoever commits a rape on a woman under 16 years of age shall be punished with RI ಅಂತ ಇದೆ 2000. ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನು ಅಂದ್ರೆ, ಇಫ್ ದ ಅಫೆನ್ಸ್ ಇನ್ ಒನ್ ಡೇಸ್ 376(3), ದೆನ್ ನೋಟಿಸ್ ಇಸ್ ಕಂಪಲ್ಸರಿ. 376 ಇದು 376(3) ಅಮೆಂಡ್ಮೆಂಟ್ 2018 ಅಂತ. This incident has taken place 2012. ಯಾವ್ದು ಸಿಕ್ತ ಜಡ್ಜ್ಮೆಂಟ್?
Judges in case 2022 ನಲ್ಲಿ
ಅಲ್ಲ,
victim or ಯಾರು
ಅಲ್ಲ, ಬಾಕ್ಸಾ ಆಕ್ಟ್ ಅಲ್ಲ ಇದ್ರಲ್ಲ.
ಎರಡಲ್ಲ 376
ಈಗಿರೋ ಪ್ರೊಸೀಜರ್ ಪ್ರಕಾರ ಕೊಡಬೇಕಾಗತ್ತೆ. ಮೊದಲಿನ ಆಕ್ಟ್ ಅಲ್ಲಿ ಅದೇನಿತ್ತು 373 ಇರ್ಲಿಲ್ಲ, ಅದು ಐ ಅಂತ ಇರುತ್ತೆ. ಅದು 376(F) ಅಂತ ಇತ್ತು ಅದು ಮೊದಲು. 376(2)(F) ಅಂತ ಇತ್ತು. ಅದು ಈಗ ಅಂಡರ್ 12 years ಅಂತ ಇತ್ತು. ಈಗ ಅಂಡರ್ 16 years ಅಂತ ಆಗಿದೆ. ಏನೇ ಮಾಡ್ತಿರ್ಲಿಲ್ವಲ್ಲ ಮೊದಲು ಇಷ್ಟೊತ್ತಿನವರೆಗೂ. ನೋಟಿಫೈ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಅವ್ರೆ. ಅದ್ಯಾವ್ದು ಜಗಜಿತ್ ಸಿಂಗ್ ಕೇಸ್ ಅಂತ ಹೇಳಿ. The material and record show not matrix and call for TCRs. The approach shall be prepared within 4 weeks from the date of the receipt of the TCR. The victim the appellant is convicted for the offense of attempt to commit rape on the victims are aged 7 years. ಇದರೆಲ್ಲ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಅಪೀಲ್ ಹಾಕಿದಷ್ಟೊತ್ತಿಗೆ ಇದು ಬಂದಿತ್ತು. ಇನ್ ವ್ಯೂ ಆಫ್ ಸೆಕ್ಷನ್ 437, 439 1A ಆಫ್ ದ ಆಕ್ಟ್. PW1, ಮದರ್ ಇಸ್ PW1 ಅಲ್ಲ, ಅದು ಇನ್ಫಾರ್ಮೆಂಟ್. PW1, the victim's mother needs to be heard in the matter. Therefore, IO shall serve. ಇದೆಲ್ಲ ನೀವೇ ಸರ್ವ್ ಮಾಡಿ ನೋಟಿಫೈ ಅಂತ ಸಬ್ಮಿಟ್. IO shall ಯಾವ ಪೊಲೀಸ್ ಅದು? CPI PIF Whitefield Police Station / Respond Police Station shall notify PW1 on this application and submit the report by date. 10 days ಬೇಕಾಗ್ಬೋದಲ್ಲ ಅವ್ರ ಮೈಗ್ರೆಂಟ್ ಲೇಬರ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ. 22 ನೋಟಿಫೈ ಮಾಡಿ ಅದು ಇನ್ಮೆಂಟ್ ಸಿಕ್ಕರೆ ಆಮೇಲೆ ಅಷ್ಟಾಗಿ ಕರೆಕ್ಷನ್ ಮಾಡೋದು. ಇದೇನ ನಿನ್ನೆ ಸೈಟೇಷನ್ 22 ಆಯ್ತು. ಬೇರೆ ಯಾವ ಡೇಟ್ ಬೇಕು? ಬೇರೆ ಡೇಟ್ 20th ಸ್ಯಾಟರ್ಡೇಸ್. ಅವರು ಸ್ಯಾಟರ್ಡೇ ಇರೋದಿಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್, ನಮಗ್ ಕೊಟ್ಟಿದ್ರು. ಇವರ ಲೋಕಲ್ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲ, ಮತ್ತೆ ಅಷ್ಟು ದಿವಸ ಇರೋದಿಲ್ವಾ? ಸರಿ, 1 ಇದ್ರ ನಿನ್ನೆದೇನು ಇದು ಕೊಡ್ತೀನಿ, ಸೈಟೇಷನ್ ಏನೋ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಸೆಟ್ ಆಫ್
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗ್ತದೆ ಅಂತ.
ಹೌದು,
ಸೋಮಶೇಖರ್ ಹರ್ವಿ ಅವರು.
ದಟ್ ಈಸ್ ಓನ್ಲಿ ರಿಗಾರ್ಡಿಂಗ್ ಇದಲ್ವಾ, ಯು ಕ್ಯಾನ್ ಡಿಕ್ಟೇಟ್. ನಿನ್ನೆ ಸೆಟ್ ಆಫ್ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ನೀವು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಇದೆ, ಯಾವ್ದು ಜಜ್ಮೆಂಟ್? ಅಲ್ಲ ಅದು ಬರೋವರೆಗೂ ನಾವು ಅದು ಉಳಿದಿದ್ ಬಿಕಾಸ್ ಎಸ್ಟರ್ಡೇ ಇಟ್ ವಾಸ್ ಓನ್ಲಿ ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ಬೋದಲ್ಲ ಅವಳು. Challenge judgment and order of conviction and sentence for the offense under section 3 and 2 IPC asked against him, the accused in SC number 50 of 2014 on the file of Principal District and Session Judge Chitradurga has preferred this appeal. The appellant was the sole accused in SC number 50 of 2014. For the purpose of convenience, the parties are referred to henceforth according to their ranks before the trial court. The appellant was prosecuted in SC number 50 of 2014 on the basis of for the offense under section 3 and 2 IPC, punishable under section 3 and 2 IPC, basis of the charge sheet filed by Chirampura Police in crime number 26 of 2014 of their police station. Crime number 26 of 2014 was registered against the appellant on the basis of complaint as per Exhibit P1 filed by PW1 Kumara. The case of the prosecution in brief is as follows. PW younger brother. PW1 is the younger brother. PW in relations to him with regard to PW what is the younger sister? Mother is also there, no?
Mother ಇದೆ.
Father is Ramanaika. Father is not examined, is there? One is the other PW4 is the sister. Then examine ಮಾಡಿದ್ದಾರೆ. Who is the father of the victim here? ಹೇಳಿ ಅವನು examine ಮಾಡಿದಾರಲ್ಲ. Mother is also not examined.
Daughter exam.
Daughter examine ಮಾಡಿದ್ದಾರೆ.
Beautify Shweta.
Interest concerning the
Long father.
PW1 is the brother, PW1 and PW1 and 4 are the younger brother and sister of deceased sister, and PW5 is the daughter of deceased. What is her name? Daughter of deceased. Kenchama. Kenchama was married to Jeevanani. One Ningappa of Susikal village, out of the said wedlock, the couple had A son Ranganath and daughter Shweta into bracket PW5. Ningappa died. Died an accidental death about 10-12 years prior to February 2014. Kenchamma. After his death, Kenchamma lived in Susikal village for about 2-3 years with her children. And then shifted to her parental place, Dodayanapalya, along with the children. About 5-6 years prior to the incident, the offense in the case, the accused and Kenchamma developed a relationship. Thereafter, leaving the children in her sister's house, she started to reside in the house of the accused.
Keremundalahatti. Keremundalahatti
In
village.
Keremundalahatti village, the accused, suspecting the fidelity of Kenchamma, used to come home drunk and assault her every day. Several advice of the elders did not yield any result. Therefore, about 15 days prior to 10/2/2014, she went back to her parental house and stayed there. The accused went there and assaulted her and forcibly took her back to his house. On 10/2/2014, in the afternoon, he, under the drunken state, he chased Kenchamma into the village and assaulted her. Without allowing the villagers to go to her rescue. The accused, during the intervening Somavara or Mangalavara, intervening night of 11/12, complaint was filed on which date? 12. 11/12.
World 214.
11/12. He committed her murder by assaulting her with the Remo 1. With the Remo 1.
Arekanat spatula.
The Arekanat spatula. And escaped from the house. Committed her murder and last sentence only.
Assaulting her with MO1 and escape from the house.
And assaulted her by assaulting, committed her murder and
He committed by assaulting her.
that's all. Next one. On receiving the information, PW1 filed complaint as per exhibit P1. ಯಾರು ಇದನ್ನು ತಗೊಂಡವರು FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದವರು ಬಿಫೋರ್ PW15 PSI
Yes,
of ಗಾಂಧಿನಗರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ದಾವಣಗೆರೆ. ಇದು ದಾವಣಗೆರೆಗೆ ಬರುತ್ತಾ ಇದು? ಚಿತ್ರದುರ್ಗ ಅಲ್ಲ?
ಎವಿಡೆನ್ಸ್ ಕೊಡೋ ಟೈಮಲ್ಲಿ ದಾವಣಗೆರೆಯಲ್ಲಿ.
ಎವಿಡೆನ್ಸ್ ಕೊಡೋ ಟೈಮ್ ಅಲ್ಲ. PSI PW15 ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟದು? P17 ಅಲ್ವಾ? ಅದನ್ನ ನೋಡಿರ್ಬೇಕು.
ಶ್ರೀರಾಮ್ಪುರ PSI ಆಗಿದ್ದಾಗ
ಚಿತ್ರದುರ್ಗ PSI PW15 then
ಶ್ರೀರಾಮ್ಪುರ
PSI of Shrirampura police station. ಚಿತ್ರದುರ್ಗ ತಾಲೂಕು ಹೊಸದುರ್ಗ itself is ತಾಲೂಕು ಅಲ್ವಾ?
ಚಿತ್ರದುರ್ಗ district.
Based on that, he registered the FIR as per exhibit P17 in crime number 26 of 2014 against the accused. On conducting the investigation, he filed the charge sheet. Next page. The trial court, on hearing the accused, framed the charge against him for the offense punishable under section 302 IPC. As the accused denied the charge and claimed trial, the trial was conducted in support of the case of the prosecution. PW 1 to 18 were examined and exhibit P1 to 19. MO 1 and 2 were marked. After his examination under section 313 CRPC, the accused did not file any defense statement or lead any defense evidence. However, D1 was marked on his way of in the cross-examination during the cross-examination of PW6 by way of contradiction. The trial court, on hearing both parties by the impugned judgment and order, held that the charge brought against the accused was proved beyond reasonable doubt by the evidence adduced by the prosecution. Therefore, the trial court convicted him for the offense under section 3. Therefore, the trial court by the impugned judgment and order convicted him for the offense punishable under section 302 IPC and sentenced him to imprisonment for life. That is till his death, and fine of 10,000. In default to pay the fine amount, to undergo simple imprisonment for 3 months. Next. The accused had challenged the said order in the above appeal, the judgment and order in the above appeal. She ಇದರಲ್ಲೂ ಅವ್ರು ಅಮಿಕಸ್ ಕ್ಯೂರಿಲ್ಲ, ಅಮಿಕಸ್ ಕ್ಯೂರಿಲ್ ಅಲ್ವಾ? ಇನ್ನು ಇದರಲ್ಲಿ ಬಂದು ಹರ್ವಿ ಅವರು ಅಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಲ್ಲಿ. ಹೌದು, ಕರೆಕ್ಟ್. ಸೋಮಶೇಖರ್ ಹರ್ವಿ. Submission of Somshekar Harvi, counsel for the appellant accused. There were no eyewitnesses to the incident. The case was based on circumstantial evidence. The prosecution was required to prove all the circumstances set up by it. Just to lead to the only hypothesis of guilt of the accused. There are material contradictions in the evidence of witnesses, contradictions and inconsistencies in the evidence of the witnesses. As per the prosecution, the cause of death was inconclusive. The witnesses in the case, material witnesses in the case were all relatives of the deceased and therefore the interested witnesses. The charges were not proved beyond reasonable doubt. As I impugned order of conviction and sentence unsustainable. The trial court committed error in expanding the life imprisonment to the death of the accused. Therefore, the impugn judgment and order are liable to be set aside. Submissions of Shri SVP, Shri so-and-so SVP2 for a response state. Evidence of PW. Merely because PW1 1, 4, 5 are the relatives of the witnesses, relatives of the victim. They cannot be added as interested witnesses. Their evidence show that on victim getting into a relationship with the accused, they had distanced themselves from the victim. PW 6 and 6 to 8. 6 to 8. Are the independent witnesses. Nothing was elicited in the cross-examination to show that there were interested witnesses. The accused by the evidence of PW 1, 2, 1, 4, 5, 4 to 8. 4 to 8. The fact that the accused and deceased were in a living relationship and she was residing in the house of the accused was established. The fact that the death was a homicidal was proved by the evidence of PW14. The death had taken place in the house of the accused. He failed to explain the same as required under Section 106 of the Evidence Act. The trial court, considering all the aforesaid facts and circumstances, held that the circumstances set up by the prosecution were proved beyond reasonable doubt. Therefore, the impugn judgment and order of conviction and sentence does not warrant any interference. Our set off ಕೊಟ್ಟಿದ್ರಲ್ಲ, set off ಕೊಟ್ಟಿದ್ದಾರೆ. Up to the death and ಯಾಕೆ set off ಕೊಟ್ಟರೋ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. 428. Next. Correct? And 16. Union of India versus Sriharan. 60 na? 59. Nashok. Nashok. That addition does not run counter to Godse and Marura. A person sentenced to imprisonment for life can claim question in this case. The benefit of section 428 of CRPC, which inter alia provides for setting of period of detention undergone by the accused under trial against the sentence of imprisonment ultimately awarded in referring to section 57 of the 57 IPC. The Constitution bench reiterated the legal principle. The provision contained in section 57 that imprisonment for life has to be reckoned as equivalent to imprisonment for 20 years is for the purpose of calculating the fractions of term of punishment. We cannot press that provision into service for the wider purpose, because observations are consistent with the ratio laid down in Godse's case. ಇದೇ judgment ಅಲ್ಲ.
20 years.
The
ನಮ್ಮ
observations
previous
are-
bench ಅಲ್ಲೂ ಕೂಡ considering this decision and the decision of honorable
Question of setting-
Supreme Court Justice Oak decision ಮೇಲೆ 20 years ಟರ್ನ್ ಮಾಡಿದಲ್ಲ ಶಶಿಧರ್ ಅವ್ರ ಕೇಸಲ್ಲಿ.
ಅಲ್ಲ ನಾವು ಬರೀ ಲೈಫ್ ಈಗ ನಾವು ಕ್ವಶನ್ ಇಸ್ 20 years ಅಲ್ಲ, ವೆದರ್ ಸೆಟ್ ಆಫ್ ಕ್ಯಾನ್ ಬಿ ಗಿವನ್ ಆರ್ ನಾಟ್ ಅಲ್ಲ. It's only if an order is passed by the appropriate authority under section 432 or 433 of the code. In the absence of such order, passed generally or specially, and apart from provisions, if any, of the relevant jail manual, imprisonment for life would mean, according to the rule of Gopal Vinayak Godse, imprisonment for remainder of the life. We fail to see any departure from the ratio of Godse's case. On the contrary, the aforequoted passage clearly shows approval of that ratio, and this becomes further clear from the final order passed by the court while allowing the appeal or writ petition. ಅದು ಅವರು ರೆಮಿಷನ್ ಕೇಳಿದಾಗ ಹಾಕೊಂಡಿರೋ ರಿಟ್ ಪಿಟಿಷನ್. The court directed that the period of detention undergone by two accused as under trial prisoners would be set off against the sentence of life imprisonment imposed upon them subject to the provisions of section 433A, provided that the orders have been passed by the appropriate authority under section 433 of the CRPC. These directions may make it clear beyond any manner of doubt that just as in the case of remission, so also in the case of set off, the period of detention as under trial would inure to the benefit of the convict, provided the appropriate government has chosen to pass an order under section 432 or 433 of the CRPC. So if they decide to give remission under section 432, ಅವರೇ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲಿ ನಾವು ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇರೋದಿಲ್ಲ ಅದಕ್ಕೆ.
Different coordinates, they can be different views. Some places have given these observations. Because the observation will be some other coordinates that the application for set out.
432 power to suspend sentence and remit. 433 power to commute. ಈ ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಇನ್ವೋಕ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ. ದೆನ್ ದೇ ಓನ್ಲಿ ಕ್ಯಾನ್ ಇನ್ವೋಕ್ ಇಟ್. That they will do.
They cannot.
433. Any person has been sentenced to punishment for an offense without conditions of or upon any conditions, suspend execution of his sentence. Appropriate government or remit the whole or any part of the punishment to which he has been sentenced. Whenever an application is made to the appropriate government for suspension or remission of sentence, appropriate government may require the presiding judge of the court report or by which the conviction was had or confirmed to state his opinion as to whether application should be granted or refused, together with his reasons for such opinion, and also forward with statement of such opinion, certified copy of the record, the trial court, etc. If any condition and the sentence has been suspended or removed based on the opinion of the appropriate government is not fulfilled, government may cancel other bail of the court. Condition on which sentence is suspended or removed maybe one to be fulfilled by the sentence of the sentence is suspended or removed, or one independent of his will. That special orders give directions as per suspension of sentence, conditions on which action should be presented and done. ಇದೆಲ್ಲ ಪ್ರೊಸೀಜರ್ ಬಗ್ಗೆ ಮುಂದಿನ subsection shall also apply to any order passed by the criminal court under section or any section of this code or of any other law which restricts the liberty of a person or imposes a liability upon him. Appropriate government ಅಂದ್ರೆ ಏನು? Appropriate government means without the consent of the person sentenced commit his sentence. 433 is commutation of sentence. Sentence of imprisonment for life, for imprisonment for a term not exceeding 14 years. Sentence of rigorous imprisonment for simple imprisonment for any term. Restriction on notwithstanding anything contained in section 432, where a sentence of imprisonment for life is imposed on conviction of a person for an offence for which is one of the punishments provided by law, or where a sentence of death imposed on a person has been committed under section 433 into one of imprisonment for life. Such person shall not be released from the prison unless he had served at least 14 years of ಇಲ್ಲಿಗೆ ಅದನ್ನ ಮಾಡ್ತಾರೆ. ಇದನ್ನ ಕನ್ಸಿಡರೇಷನ್ ಮಾಡೋದಕ್ಕೆ ಬಂದಾಗ ಸೆಟ್ ಆಫ್ ಬೇಕೋ ಬೇಡವೋ ಅಂತ ಕ್ವಶನ್.
That time you were thinking about not now. Yeah.
ಅನ್ನೋದೊಂದು ವರ್ಡ್ ಬಿಟ್ಬಿಟ್ರೆ ಅದು imprisonment for life.
ರಿಮೈಂಡರ್ ಅನ್ನೋದು ಸಾಕಾಗುತ್ತೆ ಅಷ್ಟೇ.
ಆ ಟರ್ಮ್ ಬೇಡ.
ಅದ್ರ ಒಂದ್ ಸ್ವಲ್ಪ
ನಾನು ಅಷ್ಟು
ಇಲ್ಲ ಸೆಂಟೆನ್ಸ್ ಆಫ್ ಲೈಫ್ ಅಂತ ಹೇಳೋದು IPC ಅಲ್ಲಿ ಡೆಫಿನಿಷನ್ So we'll say imprisonment for life only till his death ಅಂತ ಇದೆಯಲ್ಲ ಅದನ್ನ ಅದಕ್ಕೆ ಅವರು probably for having imposed such sentence ಇದನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. Set off. This is the latest agreement. Justice 2016. All judges have rendered different judgments. Page 1 ಇಂದಾನೆ ಶುರು ಆಗುತ್ತಾ?
Judgment of conviction and sentence does not warrant a new.
Considering the submission of both sides and the material and record, the question that arises for the court's consideration is whether the impugned judgment and order of conviction and conviction is sustainable in law. Whether the impugned order of sentence is sustainable in law. Number 2. Point number 1 ನಲ್ಲಿ ಮೊದಲು ಬರ್ತಾರೆ. the relationship between the accused, accused one, relationship between PW 1, 2, 1,
Four.
4 and 5, 4 and 5, and the deceased was not disputed. It was also not disputed that victim Kenchamma was married to the father and party ಮಾಡಿದಾರಲ್ಲ ನಿಮ್ಮ ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡುವಾಗೆಲ್ಲ ನೋಡಿ victim was married to Ninganayakana. One Ningappa of Suzikal village about 20 years prior to the incident. Yeah, and he died about 10-12 years prior to the incident by drowning. It was also not disputed that after the death of Ningappa, the victim lived with her children in Suzikallu village for about 2-3 years, and thereafter she had shifted to her parental house in Doddayanapalya along with her children. Thereafter, she was vending flowers in the villages. Next one. The case of the prosecution was based on there were no eyewitnesses to the incident. The case of the prosecution was based on the circumstantial evidence. The prosecution to bring home the guilt of the accused relied on the following circumstances. Number one, that the accused and the deceased when he was married ಅಂತ ಬಂದಿದೆ ಎಲ್ಲ ಒಬ್ರು ಎವಿಡೆನ್ಸ್ ರಾಮನಾಯಕ ಅನ್ನೋರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಮ್ಯಾರಿಡ್ ಮಕ್ಕಳಿದ್ವು ಅಂತೆಲ್ಲ ಬಂದಿದೆ ಎಲ್ಲ ನೀನು he was unmarried ಅಂತ ಹೇಳ್ತಾರೆ wherein a living relationship and they were living together in the house of the accused in Keremundalahatti in the limits of your police station, Srirampura police station. Number 2, motive that the accused and the accused suspecting the fidelity of Kenchamma subjected her to physical cruelty, and soon before her death, he was found assaulting her. Kenchamma was found dead, homicidal death in the house of the accused. Next, the accused was the conduct of the accused dash accused absconding from the scene of offense soon after the incident, and his failure to explain the unnatural death as required under section 106 of the Evidence Act. Next one. Regarding the motive and the relationship of accused number 1 and 2. The accused and the deceased. PW 1, the brother of 1, the brother, and PW 4, the sister. PW 5, the daughter of the deceased. Categorically deposed about the accused, I'm sorry, the deceased, developing deceased was a widow and having children, developing a relationship with the accused. And shifting to Keramandalahetti and living with the accused in his house in the said village. They also deposed about the victim leaving behind her children in the house of ಒಬ್ರು PW 1 ಮನೆಯಲ್ಲಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ, ಇನ್ನೊಬ್ರು ತಂಗಿ ಮನೆಯಲ್ಲಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ಇನ್ ಅವರ್ ಪೇರೆಂಟಲ್ ಹೌಸ್ ಅಂತ ಹೇಳ್ಬಿಡ್ತೀವಿ ಅಷ್ಟೇ, ಇನ್ ಅವರ್ ಪೇರೆಂಟಲ್ ಹೌಸ್. ನೋಡಿ ಇದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ನನ್ನ ತಂಗಿ ರತ್ನಮ್ಮ ಇಟ್ಕೊಂಡು ಅನ್ನೋರು ಇಟ್ಕೊಂಡು ಸಾಕಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ. PW 4 ಏನ್ ಹೇಳ್ತಾಳೆ ಅಂದ್ರೆ ಅವನು ಕುಮಾರನ್ ಮನೆಯಲ್ಲಿದ್ಲು ಅಂತ ಹೇಳ್ತಾಳೆ. PW 4 ಇಲ್ಲ ಕ್ಲಾಸಿಕ್ಸ್ ಅದಕ್ಕಿಂತ ಇನ್ನೊಂದು. ಸಿಮಿಲರ್ಲಿ PW ಚಂದ್ರಾಬಾಯಿ PW 6 to 8, the residents of Keremundalahatti village and the neighbors of the deceased and the accused categorically deposed that the accused and deceased were living in their village in the house of the accused as husband and wife. They further deposed that husband and wife in the cross-examination of the aforesaid witnesses. ಈಗ ನಾವು ಹೇಳ್ತಿರೋದು ಬರೀ ಅವರು ಒಟ್ಟಿಗೆ ಇದ್ದಿತ್ತು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ. In the cross-examination of the aforesaid witnesses, in fact seriously dispute ಮಾಡಿಲ್ಲ. The accused and deceased living cohabiting with each other in the house of the accused was not disputed. To prove that the death had taken place in the house of the accused, the prosecution examined PDO ಒಬ್ಬರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾರಲ್ಲ, ಅವ್ರನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿಲ್ಲ ಅವರು. Prosecution relied on the evidence of PW 9. PW 9, the PDO of Keremundalahatti. PW 9, the PDO of PW 9 is at page number
102. ದೊಡ್ಡ ತೆಕಲೊಟ್ಟಿ ವಿಲೇಜ್.
ದೊಡ್ಡ ತೇಕಲವಟ್ಟಿ ವಿಲೇಜ್. ಇದು ದೊಡ್ಡ ತೇಕಲವಟ್ಟಿಯಲ್ಲಿ ಕೆಂದಲಮಟ್ಟಿ ಒಂದು ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಗೆ ಬರುತ್ತದೆ. ದೊಡ್ಡ ತೇಕಲವಟ್ಟಿ ವಿಲೇಜ್ and exhibit P5, the demand register extract. PW 9 deposed that Keremandalahatti comes within the Dodda Tekalavatti Gram Panchayat limits, and on the requisition of the IO he issued exhibit P5, the demand register extract relating to the said house. Exhibit P5. Exhibit P5. ಅವ್ನ ಹೆಸರಿದೆ ಅದ್ರಲ್ಲಿ ನಮ್ಗೆ ಕೃಷ್ಣ ನಾಯಕ ಅಂತ ನಾಗರಾಜ್ ಕೃಷ್ಣ. Exhibit P5. The demand register extract shows that the scene of offense was bearing door number 305 and standing in the name of in the said document. The accused was shown as the khatedar and possessor of the said property. PW9 was not cross-examined to dispute the correctness of exhibit P5. By such evidence, ಕೊಡಿ ಅದು ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತೀನಿ ಅಂತ ಕೊಡಿ ಅದು ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, local subdivision.
Regarding ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ 3 ದಿವಸ ಹೊಡಿತಿದ್ದ ಅಂತ ಇದೆ. ನೀನು ಸಾಯಿಸ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಸ್ಪೋರ್ ಆಫ್ ಮೂಮೆಂಟ್ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಅವ್ರಿಗೆ. ಇಲ್ಲವೇ ನಾನು ಹೆಂಡತಿ ಹೊರಮನೆಯಿಂದ ಕರ್ಕೊಂಡು ಬರುವಾಗಲೂ ನೀನು ಸಾಯಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿ ಕರ್ಕೊಂಡ್ ಅಂತ ಹೇಳಿದ್ದೆ. ಅವಾಗಲೂ ಹೊಡಿತಿದ್ದ ಕಂಟಿನ್ಯೂಸ್ ಸ್ಪೋರ್ ಆಫ್ ಮೂಮೆಂಟ್ ಆಗಿ ಆಮೇಲೆ ಆಕೆ ಕುಡಿದ್ರು ಅಂತ ನೋಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲಿ ಆಕೆ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಎಕ್ಸಾಮಿನೇಷನ್ ರಿಪೋರ್ಟ್ FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಆಲ್ಕೋಹಾಲ್ ಕಂಟೆಂಟ್ಸ್ ಇತ್ತು ಅಂತ ಇಲ್ಲ ಅದರಲ್ಲಿ. ಎಸ್
Therefore, person is not less than 14 years, at least minimum 14 years should be undergone. 14 years already considered one of the. How this from what date they have to consider 14 years? How this person, then the under period should be set out.
if they want to take a decision under 432 433, then they have to refer it to the seek the opinion of the concerned court.
How many they are not never the same, they repeat the judgment if not given the setup, they are not considered the same from the date of judgment. If where in case the setup is given, they consider the custody from the date of admission.
Yes.